Yes. Just looking online, there's still a court hearing scheduled for tomorrow when I got a notice of appearance. Yeah, for the 28th. Oh. Now, I thought that maybe my public defender wanted me to call them. Yes. Jack, I don't call a public defender that doesn't call me and ask me if I want to change the court date. Pooch. I'm the accused that happens to have all the evidence that I wasn't in Brendan, Washington. And when I look at exactly who I've been emailing for the last 2 years, yes, you can copy and paste every email address, and I feel confident to say that 99% of them you will be easily identifiable as oaths, badges, or attorneys. Oh. Now, we've been having this difficulty with the actual laws of the United States. I got upset at the police and sheriff's department because they keep fucking up my life when they got an email that day. Now, these emails that I sent that evening, yes. And then there was the videos that I made during the day, yes. One of three, well, I was probably out messing around after dinner. It was in June 16th of 2017. If you start with video 13 of 13 and go backwards, yes. Video 12 of 13, the actual order is reversed. The first video is 13, yes. And the last video is 1. You can see it right here? Yes. I put that on video number 12 for those in office that are confused. Now, video 11 of 13, yes. Assistant Deputy Chief of Police of Port Angeles, Jason Viada. I can't be in Brennan when I'm in Port Angeles, Washington. That means I couldn't have committed any violations of the restraint provisions of the protection order. I couldn't be in Sequim, Washington on December 31st of 2015 when I was in Port Angeles, Washington at that morning. Yes. In fact, I looked at the email that I sent that day. Oh, I wonder, there's an actual screen print from this public library at 4:48 p.m. But you as a police department would not admit the evidence that I wasn't in Sequim. Now, I provided all of this evidence to you, law enforcement, and you stood there and said, well, we're just not going to do what the law says. Now, what gives you the right to think that you have the right to put me in a mental institution when you have the evidence to exonerate me of any crimes at all, inclusive of the May 2012, yes, or I was not given any notice or opportunity. It could not have been a criminal offense, right? I contacted Healthy Families of Clallam County. It would have been a violation of the restraint provisions. Now, all these employees of the city of Seattle's government, yes, they got an email from me. Why don't you call them and see if they did? And Officer Johnson, you got an email from me. Pooh, why don't you call the police department in Port Townsend? Now, A. Roman Poe, you got an email from me. Why don't you, as police officers, contact the Port Townsend Police Department and tell them Paul was not in Brendan, Washington? Yes, and he did not email any of Heidi's co-workers in Brendan, Washington. Oh, now that leaves the big door open, doesn't it? Oops, exactly who was it that's been doing all this crime? Oh, because I haven't, as I've told you maybe 1,000 times. Ooch. And for some reason, you think that somebody can be two places at the same time. I keep asking you to remove the fucking order known as the protection. Remove the fraudulent protection order. Remove the fraudulent dissolution of marriage. Remove them. Now, June 16th. June 16th. I made 3 copies of it. I put it on Facebook. You could go through the archive. You could find the actual evidence proving my innocence. And then I could have my sons. Now, instead, you've been making this little conspiracy that you're going to prosecute me when the police department knows I was not there. Can you tell me how that's not criminal? How exactly is it not criminal? See, um, um, Bruce Hanafy, attorney for the defendant. I've attached true and correct copies of the permanent protection order entered on July 31st of 2015. Notice of service made on August 15th. Yeah. Now it's a permanent protection order. Yes. That allegedly there was 2 criminal counts, traffic citation, in Sequim, Washington, when I was in Port Angeles, Washington. Now, obviously, you've arrested me enough times. You made me stay in jail enough. Do you have to prove the point that you're infallible, that I'm going to do what you say without you doing what the law requires? Then there's this personal recognizance. Yes, on personal recognizance. Yeah. Hereby order that the above named defendant shall be released from county jail pending trial. Following conditions. Yes. Court having determined there is substantial danger that the defendant will commit a serious crime or that the defendant seeks to intimidate witnesses or otherwise unlawfully interfere with the administration of justice, poses the following additional conditions. Heidi Lee Budnick, yes. No contact whatsoever with complaining witnesses or witnesses. Now, this says no contact, which very similar to a no contact order. Yes. Yes, it does. Now, that's a little different than violating the restraint provisions. Ooh. Now, it's not exactly like the no contact orders that they describe in, what's it called? The domestic violence bench book for those that are judges. Now, I would think that if this had been violated any time since the 19th day of September of 2017, you could immediately put me in jail. It says no contact. Yes, it does. Defendant shall not go to the following geographic area, premises, residence, work, school, above. Did you tell Judge Landis that I wasn't there and that you got emails on June 16th? See, she actually did issue a no contact order. Yes. Yes. Now, the defendant shall appear in court on November 1st of 2017 at 9 a.m. Yes, I did appear in court. I have not violated any other criminal laws. I've appeared in court every time I've had a notice of appearance. Yes. Now, the conditions of the release and any other condition may be attached. I agree to follow said condition. Understand that a violation will lead to my arrest and may be punishable by contempt of court. Violating the conditions of personal recognizance. Yes. I could get punished as a contempt of court. Yes. I agree and promise to appear before the court or any place as this court may order upon notice delivered to me at my address stated, homeless, below, or upon notice to my attorney, Jack Range. Yes. I didn't get a phone call from Jack. No, he didn't. Now, since you say that I'm you're violating the conditions of personal recognizance stated below or upon notice to my attorney. Yes. Now, this should be a notice from the state of jurisdiction that would have been issued to the public defender's office that it was docketed for the 28th of this month. Yes, it was. This putting it on the court website without notice to my attorney. Yes. I further agree and promise to keep the office of the prosecuting attorney informed of any changes of either my address or telephone number. This phone number still works right here. Notice failure to appear when required by court will result in the defendant's arrest. Now, as it says, may order upon notice delivered to me. Yes. Notice of appearance. You remember when I got that last time I was in court? Yes. They actually did give me notice. Yes. And since Jack didn't call me, I'm not going to call Jack. Now, Jack has a problem with prosecuting attorneys. I don't have a problem with them. Stated below or upon notice to my attorney. Yes. Now we had this other question about personal recognizance. Did we have Judge Porter? Yes. Let's look at that. Order for release and conditions. Yes. Now, just so you know, defendants shall contact court-appointed counsel. I contacted Bruce Hanafy within 48 hours. Yes. And the court-appointed counsel is the public defender's office. Maintaining my current homeless address so that you could continue to send it to the wrong address. Pooch. Do not use email to communicate. Yeah, I haven't violated that since the 5th day of January of 2016.